Welcome to The Explainer. Today, we're diving into a truly fascinating, almost darkly comedic case from the Constitutional Court of South Africa. It's the Minister of Justice versus Ntuli. What we're going to unpack here is essentially a perfect storm, a moment where high-minded constitutional law collided head-on with everyday bureaucratic reality. It's the story of what happens when the highest court in the land issues a profound, game-changing mandate about fundamental human rights, and the government, well, essentially misplaces the memo.
Let's kick things off with a pretty crucial number, 17, specifically 17 months. Now, this was the exact and, frankly, very generous amount of time the Constitutional Court originally gave the South African government to fix a massive legal defect in their criminal justice system. They had nearly a year and a half to draft a solution, consult with experts, and actually change the law.
But contrast that generous window with this number, 5. Just 5 days. That was the mere 5 days remaining on the clock when the Department of Justice finally woke up, realized they had done absolutely nothing to fix the law, and frantically hit the panic button.
So here is our roadmap for today's explainer. First, the initial conflict. Then, a timeline of inaction, followed by the last-minute panic, the procedural smackdown, and finally, why rights have to triumph over bureaucracy.
Section 1. The initial constitutional conflict and the roots of the problem.
So the whole mess actually starts back in December 1995. The court was looking at Section 3094A of the Criminal Procedure Act. Basically, this rule prohibited convicted prisoners in lower courts from appealing their cases in person unless they first jumped through a hoop and got a certificate from a judge saying they had reasonable grounds. Well, the Constitutional Court took one look at this and struck it down. They ruled it unconstitutional because it flat out denied convicted prisoners their fundamental right to a fair trial, not to mention equal protection under the interim constitution.
But here's the thing. The court didn't just void the law overnight. They knew that striking it down instantly could trigger absolute chaos and overwhelm the courts with a flood of appeals. So they suspended their declaration of invalidity to give the state time to get its act together. They drew a firm line in the sand. Parliament had until April 30, 1997 to remedy the defect. If they didn't, the law would automatically become invalid.
Which brings us to Section 2, a timeline of inaction, or how to waste 17 generous months.
You literally can't make this up. Let's look at this agonizing sequence of delays. The judgment drops in December 95. The Department of Justice doesn't even notice it until February 1996, and their only reaction is to tell the state attorney to close the file. It takes a casual hallway reminder months later for them to realize, oh wait, we actually need to do something. A consultant gets hired a staggering 9 months late in September. The minister is only informed in December 96, a full year after the ruling. And the cherry on top, in March 1997, when they finally decide they need an extension, an official literally loses the file. They couldn't find it until another official came back from an overseas trip. Just listen to this detail from the court documents regarding a department director, Mr. Bassett. It is absolutely staggering. A supreme constitutional directive, one dealing with the fundamental rights of imprisoned people, was treated so casually that a director only really paid attention to it because a colleague happened to bring it up in a water cooler chat months after the fact.
All right, Section 3. The last-minute panic as they're officially running out of time.
Picture this. It's Friday, April 25th, 1997. The absolute drop-dead deadline is the very next Wednesday. With just 5 days left, the state attorney scrambles. They file this emergency, out-of-term application to the Constitutional Court, essentially begging for an extension all the way to the end of November 1998. They wanted over a year and a half of extra time, purely because they dragged their feet and lost a file.
But you know how it is. When you're panicking, you make mistakes. And blind panic led to some incredibly sloppy work here. The government's application was riddled with absurd defects. The founding affidavit barely even bothered to explain the delay. They tried to schedule a hearing in just 4 days without even asking the president of the court. They even cited Ntuli as the respondent. That's the guy whose individual case had already been finalized. He had literally zero legal stake in the matter anymore. Meanwhile, they completely ignored the Attorney General, the person who actually did have an interest in the outcome.
Moving to Section 4, the procedural smackdown and the court's ultimate response.
Look at the rules versus reality here. Rule 17 dictates strict procedures for direct access to the court. You need exceptional circumstances, directions from the president of the court, and proper notice to interested parties. The state attorney completely ignored all of that. They unilaterally demanded a hearing date out of term, served the papers to the Legal Resources Center instead of the proper parties, and totally bypassed the president of the court while he was away in Cape Town. It was, quite frankly, a procedural disaster.
Now, this brings up a really important foundational legal concept called functus officio. Essentially, this is the principle that once a court pronounces a final judgment, its authority over that specific matter is totally finished. The court had to seriously question if they even possess the constitutional power to reopen and alter a finalized judgment just because the government department was incompetent.
The court basically said, okay, let's assume, just for the sake of argument, that we do have a discretionary power to extend the deadline. We firmly will not exercise it here. Why? Because giving the government more time would literally require the court to revive an unconstitutional law. It would make the Constitutional Court a willing, active participant in the ongoing violation of the fundamental rights of prisoners. And there was absolutely no way they were going to do that.
And that leads to Section 5, Rights over Bureaucracy, the Ultimate Showdown. Judge President Chaskalson, who delivered the judgment, absolutely did not mince his words. He looked at the Department of Justice's massive administrative failure and bluntly called it a sorry tale. He stated clearly, for the record, the delays were inexcusable. The government tried to play the card of blaming the transition to the new constitutional order, but the court quickly pointed out they had already factored all of that in when they gave them the generous 17-month window to begin with.
The government tried one last, pretty desperate argument. They claimed that if the court didn't grant the extension, the justice system would be totally overwhelmed with appeals, prejudicing the administration of justice. Well, the court fired back with this profound statement. They reminded the state that recognizing the fundamental rights of accused persons isn't some roadblock to the administration of justice, it is an essential component of it. You literally cannot claim to administer justice while actively denying people their constitutional rights.
So the final verdict was absolute. Case dismissed. The state's request for an extension was completely thrown out. No order was made as to costs, mainly because the opposing counsel had just been brought in to assist the court as amici curiae, friends of the court. But the result was crystal clear. It was a massive, uncompromising win for the supremacy of the 1996 Constitution over bureaucratic neglect. The unconstitutional law was gone for good. So think about this as we wrap up today. It forces us to ask a really difficult question. When bureaucratic incompetence meets constitutional rights, who actually pays the price? In this specific case, for 3 whole years, prisoners were denied their rights simply because of administrative apathy. It really leaves you to wonder, as we navigate our own complex systems today, exactly how often our most fundamental protections are just quietly misplaced in some government filing cabinet. Definitely something to think about. Thank you so much for joining me for this explainer, and I'll catch you in the next one.